Hello and welcome to this recorded session of why talent reviews are now a huge legal risk. My name is Martin Lanek. I am the CEO of Pinsight and I hold a doctoral degree in industrial organizational psychology. I want to, before I start, just say that I'm not a lawyer, but the commentary that I'll provide has implications for HR practice. We care deeply about bias at Pinsight because our mission is to bring fairness to leader selection, development, and succession. And we work very hard to level the playing field. So we periodically monitor the developments in policy and court cases so that we could help our clients to make unbiased decisions about their key talent. Today's webinar will focus on three areas: the significance and implications of the Woods-Early versus Corning ruling for common talent management practices, especially talent reviews. Then I'll talk about how to determine if your current talent management practices could place you at risk for a legal challenge. And lastly, I'll talk about how to minimize your risk while also developing your top talent. So let's get started. The legal landscape is quite litigious in the US. In 2018, the EEOC report shows that over $500 million were secured for victims of workplace discrimination. There were over 67,000 of victims that were helped in 141 different lawsuits. Discrimination lawsuits are happening. They're not necessarily on the rise, but this environment is very active. What does this mean for common talent management practices? Historically, industrial psychologists and many HR professionals have focused on discrimination in the talent acquisition, especially hiring phase. We examined the adverse impact of different psychometric tests, for instance, to make sure that the screening procedures are not resulting in adverse impact. But lately we're seeing that there is a shift, increased interest in other types of talent management practices that are more on the existing employee side. We're seeing that employees are challenging who gets access to leadership development or how decisions are made around high potentials and successors. So there's perhaps a shift in discrimination cases that is more towards learning and development succession planning, where historically perhaps we haven't seen as much activity. So how do companies identify high potentials? How do you identify high potentials in your company? Generally, there are three most common methods. The first one is performance ratings. Some organizations rely on manager nominations. And then, unfortunately, a very small portion of organizations depend on psychometric assessments. And here's the data here. The data is a bit old. We're coming from 2012, but in a recent poll, we've seen the same trends hold. Most organizations select high potentials based on performance ratings. Again, a large majority is relying on manager nominations, and only about 10% are relying on psychometric assessments. I find this really interesting because when you compare that with the accuracy of these methods, it makes you wonder, why is it that organizations are largely relying on the tools that are not producing the most accurate results? And this is perhaps why we are seeing that about 60% of managers tend to fail in their new role within their first year. In addition to the lower accuracy of performance rating, we suffer from group differences. We have seen in meta-analysis, so studies that look at the trends across hundreds of independent studies, that there are differences in managerial ratings of performance and potential. For instance, white Americans are 1.7 times more likely to receive better performance ratings than African Americans. They're 1.1 times more likely to receive better performance ratings than Hispanic Americans. And men are 1.0 times more likely to receive better promotion potential ratings than women. And these biases that are inherent in manager ratings can potentially result in adverse impact and put you at a legal risk. So what do the courts say about manager? Classic study, a court case from 2011, Dukes versus Wal-Mart, ruled that employment practices that rely on manager ratings do not constitute and do not meet the commonality requirement to proceed as class action lawsuit. And this is very important because it essentially, the Supreme Court ruled that decisions of individual managers do not constitute a specific employment practice. It's the exact opposite. So individual managers and their decisions are the exact opposite of a commonality that we would need to see in order for the case to proceed as a class action lawsuit. But this has February of this year in Woods Early versus Corning. It's a race color discrimination case on behalf of African American employees who were denied access to networking, leadership classes, promotion, and so higher pay. And Corning attorneys argued that the case doesn't meet the commonality requirement based on Dukes versus Wal-Mart. But the federal court in New York ruled for the case to proceed. And this new ruling has implications especially for talent reviews and other practices, because this court has determined that discretionary decisions can be the source of a common claim if they are the outcome of employment practices or policies that are controlled by higher level directors, or if all decision makers act together as one unit. That's exactly what's happening in a talent review. Because discretionary authority exercised by higher level corporate decision makers is applicable to a broad segment of the corporation's employees, it is more likely to satisfy the commonality requirement. So what does this mean? This means that whenever we have a group of upper manager that is exercising uniform discretion, this might establish commonality requirement for the class action lawsuit to proceed. And this includes, of course, talent reviews and any decisions that are made in talent reviews, such as the placement of employees in the 9 boxes, high potential identification, identification of successors, or access to training, development, and other special resources that help people proactively move up to higher paying jobs. So what do you do about this? It turns out that there are 2 things that you can do to minimize your risk. The first one is to periodically monitor the adverse impact of your internal talent management practices. I'll show you how to do that. And second thing is to add objective assessment data to the mix. So let's start with adverse impact from a calculation perspective means that one group is selected at less than 80% of the selection rate of the group with the highest selection rate, which historically has been white men. How do you calculate this from a 9 box? Well, let's work through an example here. So let's say that you have 400 mid-level managers that you are reviewing in multiple talent calibration sessions. And 250 of those are women, 150 of those are men. And now we're going to place them in the 9 boxes. We decide that 15 women and 15 men will make it to the top right corner. These people as high potentials, and we put them in special high potential programs. We give them access to scarce resources like networking with executives, and we're going to be actively grooming them for higher level positions. And we think that because we selected equal number of men and women, that adverse impact is unlikely. But what's happening in the other boxes? 235 women end up being placed and 135 men. So now we calculate the ratio when we are interested to see if adverse impact has. The selection ratio of women is 15 divided by the total number of mid-level managers that are women, which is 250. And we end up with a selection ratio of 6%. This is for men. So we have 15 men out of 150. The selection ratio of men is 10%. Did adverse impact occur? Well, we compared those 2 selection ratios, and we women were selected at 60% of the selection ratio of men, and hence that's below the 80% threshold, so adverse impact has occurred. You can do this calculation on other protected classes like age, different ethnic groups, racial groups, veteran status, disability, any protected classes. Now, the second thing that you can do is to add objective assessment data to the mix. And I'm showing you here an example of a 9-box that is put together based on objective assessment center ratings. And we see that assessment centers especially have lower and generally it result in lower adverse impact. The added benefit here of an assessment center is that you are helping managers make more accurate decisions during talent reviews because you are giving them access to additional objective data on top of their own ratings and experiences with those employees. However, all assessments are not perfect and they do show group differences. So I just picked out the black-white differences on assessments, and you see that the difference is the highest in intelligence scores, then a bit lower on assessment, situational judgment test, and even lower on personality. So no assessments are perfect, and the key is in combining assessment so that you are balancing the validity, the predictive power, and the accuracy of the assessment with the bias in there, so you are limiting adverse impact. At Pinside, the combination that we use is a combination of a virtual assessment center with personality measures and then cognitive ability tests. So to conclude, we'll see more class action suits happening that they are challenging talent management practices and especially talent reviews because they do pose a legal risk right now based on the latest court ruling. However, there are several things you can do to minimize the risk in your organization, and you can monitor adverse impact on an annual, biannual basis, and you can add objective measures to the mix so that you are helping your managers make better decisions about your existing talent. Thank you very much. I appreciate your time. Again, my name is Martin Lennick. I'm the CEO of Pinside. And if you'd like to learn more about our integrated leadership assessment and development technology that supports talent reviews and succession planning, don't hesitate. Go to pinside.com and request a demo. Thank you. Bye-bye.